As regards the Senate refusal to grant His Excellency Gachagua an adjournment after he allegedly fell ill during the trial, His Excellency Kindiki observed that His Excellency Gachagua was granted an opportunity to appear in person and be represented by advocates of his choice before both houses of Parliament. He deposed that he made both oral and written representation at both houses of Parliament, challenged the inculpatory evidence before houses of Parliament, and through cross-examination of all adverse witnesses in the trial held at the Senate. Further, he deposed that H.E. Gachagua appeared healthy during his initial testimony and found it highly suspicious that he failed to present any formal medical diagnosis or report to the Senate to substantiate the sudden illness. He argued that granting the requested 3-day adjournment would have violated strict constitutional timelines under Article 145(4) of the Constitution that required the Senate to conclude impeachment proceedings within 10 days, failure which would have potentially plunged the country into a constitutional crisis. In his supplementary affidavit, His Excellency Kindiki opposed the late introduction of medical records by Dr. Daniel Gikonyo. He faulted the affidavit for having been sworn a year and a half after the impeachment events and was introduced only after the primary petitioner had already closed their case. He highlighted material inconsistencies regarding the timing, preparation, and late disclosure of the medical records. Specifically, he highlighted that they were never presented to the Senate, the primary constitutional forum. His Excellency Kindiki urged his case further through written submissions dated the 1st of October 2025, which were highlighted by Learned Counsel Dr. Muthomi Thiankolu, Senior Counsel, and Mr. Kenson Muteithia. They structured it to symmetrically address both the substantive and procedural validity of the impeachment process in the National Assembly and the Senate, as well as the constitutional legality of His Excellency's nomination and election. Regarding the substantive validity of the impeachment, Dr. Thiankolu, Senior Counsel, submitted that His Excellency Kindiki was lawfully apologies, there's a mistake here. That His Excellency Gachagua was lawfully removed from office on 5 distinct counts, which included making persistent inflammatory public statements, undermining the decisional independence of the judiciary, and publicly attacking the NIS. To support the argument that the judiciary should not substitute its own judgment for that of Parliament, it was his case that the Supreme Court, in the case of Sonko, and the High Court decision in Wambora, held that the courts exercised only supervisory jurisdiction over impeachment disputes and could not act as a super legislature to review the sufficiency of the evidence presented to Parliament. In defense of the procedural mechanisms employed, His Excellency Kindiki urged that the National Assembly fulfilled its mandate by adequately informing the public and facilitating public participation, referring to the BAT case. He further implored the court to find that the strict 12-line impeachment timeline was a rigid constitutional framework, and to fortify its position, he referred to the Supreme Court's decision in MYKE, where it was observed that timelines were not subject to alteration. In challenging the claim of denial of the right to fair hearing, His Excellency Kindiki asserted that the Senate's refusal to grant a 3-day adjournment was In challenging the claim of denial of the right to a fair hearing, His Excellency Kindiki asserted that the Senate's refusal to grant a 3-day adjournment was an attempt to sabotage the proceedings and trigger a constitutional crisis. It was his position that His Excellency Gachagua had failed to produce medical evidence to substantiate his sudden illness. He reiterated that granting the adjournment would have blatantly violated the strict, non-modifiable constitutional timelines. Turning to the validity of His Excellency Kindiki's assumption of office, Dr. Thiankolu submitted that his speedy nomination, electoral clearance, and political party membership was justified. He drew support from the court's decision on 31st October 2024, which established that the critical functions of the Deputy President's office abhorred a vacuum and demanded expeditious action. Finally, His Excellency Kindiki contended that the statutory laws governing appointive state offices, such as the Public Appointments Parliamentary Approval Act, did not apply to the elective office of the Deputy President.
We now come to issues for determination. Upon careful consideration of the petitions, the responses thereto, the written and oral submissions of all parties, we have distilled the following issues for determination. For clarity and issue of reference, the principal issues and their attendant sub-issues are set out below. Issue number 1, jurisdiction. And under jurisdiction, the issue is the justiciability of the petitions filed in light of the doctrine of separation of powers and the political question doctrine. Issue number 2, predetermination and bias. Whether there was predetermination and bias by the mover of the motion, the Speaker of the National Assembly, and the Senate during the proceedings. And 2, whether the 1st to the 11th respondents conspired or schemed to remove Honorable Gachagua from office in violation of Articles 1, 27, and 38 of the Constitution. Issue number 3, public participation. Whether there was adequate public participation at the National Assembly. 2, whether the Senate was obligated to conduct public participation, and if so, to what extent. 3, whether public participation was required at the point of nomination and appointment of His Excellency Kindiki. Issue number 4, constitutionality and legality of the standing orders. 1, whether standing order number 64, sub-order 2, and 65 of the National Assembly are unconstitutional. 2, whether standing order number 75, 78, 79, and 80 of the Senate are unconstitutional. Issue number 5, composition of the National Assembly and the IEBC and the nomination of the Deputy President. 1, whether the National Assembly was properly constituted to consider the impeachment motion in light of the 2/3 gender rule. 2, whether the nomination of a Deputy President can be legally finalized or approved in the absence of fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. 3, whether the nomination of Hon Kindiki while serving as a cabinet secretary is constitutionally infirm for violating the eligibility criteria under Article 148 as read with Article 137. Issue number 6, constitutional processes. Whether the Senate was obligated under Article 150 sub-Article 2 to apply Articles 144 and Article 145 with the necessary modifications to the Deputy President, and whether its failure to do so rendered the process invalid and unconstitutional ab initio. We'll also look at relevant standing orders and doctrine of immunity. 2, whether Parliament was obligated to consider and exhaust alternative accountability mechanisms, that is, criminal, civil proceedings, EACC, DCI, etc., and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. 3, whether the Senate ought to have established a special committee under Article 145, sub-Article 3 of the Constitution. 4, whether the speed of the gazettement of the Senate resolution, the nomination of His Excellency Kindiki by His Excellency President Ruto, and the voting by the National Assembly on His Excellency Kindiki as the DP nominee contravened the Constitution and the law. And issue number 7, fair trial, whether the trial conducted by the Senate in respect of His Excellency Gachagua was lawful, fair, and in conformity with the constitutional guarantees of fair administrative action and fair hearing under Article 47 and Article 50 of the Constitution, respectively. We shall now turn to the analysis of each issue and its attendant sub-issues in the order set out above.